Good morning, everyone, and welcome to this morning's webinar on contracting with the public sector. I'm now going to pass over to our speakers, Paul Barton and James Buckingham.
Thank you, Jess, and very warm welcome to everyone who's joining this webinar. Today we're going to be focusing on contracting with the public sector. I'm Paul Barton, a partner in Fieldfisher's technology and data practice, and today I will be co-presenting with my colleague James Buckingham, who's also a partner in the same team. Both James and I have considerable experience of working on public sector deals. In my case, I've worked on public sector projects for over 25 years, and we've both advised government customers on some of their most strategically important technology-enabled projects, as well as some of the leading suppliers of software and services on their government contracts. James, do you want to say a few words of introduction?
Thanks, Paul. As you mentioned, I'm a partner in the Fieldfisher technology and data practice. I do have many years of experience advising on public sector procurements acting for both customers and suppliers. Paul and I are pleased to have the opportunity to speak with you today about contracting with the public sector, and we will endeavour to share with you some of the insights that we have gained over the years. Next slide, please, and back to Paul.
So, what have we got in store for you today? Well, we'll start by reminding you why the public sector is different. We will then explain a few things about the public procurement process, so hopefully you can use it to your advantage to win more public sector contracts. We will then give you some context on the contracts that are being used by the public sector and what scope there is for negotiating their terms and managing legal risk. We will identify for you some of the key issues that suppliers often have with the government contract terms, i.e. the red flags. And finally, we hope to conclude with some comments on how you can increase your chances of winning government contracts. So next slide, please, and over to James.
Thanks, Paul. So why is the public sector different? In my opinion, there are two main points of difference between the public sector and other sectors. Those are its size and the regulatory landscape within which it operates. These inform how it deals with vendors and should inform your sales strategy. Looking at the size of the public sector in some more detail, it's easy to understand why businesses want to sell to the public sector. It spends a significant amount of money buying goods and services. In the last financial year, it spent $379 billion, of which approximately 16 to 20 billion was spent on IT. So public bodies may make good potential customers. The regulations and public procurement process are a deterrent for many businesses. Brexit promised a bonfire of EU regulations, but that has not occurred. Government signals its intention to reform public procurement with the publication of a green paper in 2020. But Brexit does not mean that public procurement becomes less regulated. This is due in part to the fact that EU procurement principles of transparency, equal treatment, non-discrimination, and open competition are enshrined in the UK's international treaty obligations. Public bodies will continue to be required to advertise contracts over a prescribed value and conduct a structured procurement process, and to award contracts in accordance with award criteria that have been disclosed to bidders. The procurement bill is the next step in the government's reform agenda. It was introduced into the House of Lords in May 2022, and it is designed to introduce a single legal framework for the award of public contracts. And this includes utility contracts, concession contracts, and defence and security contracts. In addition to international and domestic laws, there are also numerous policies and guidelines that public bodies are required to comply with when purchasing goods and services, and which suppliers to the public sector need to be aware of and understand. The public sector's size and the complex regulatory framework within which it operates does create challenges. Where there are challenges, there are also opportunities. So this brings me on to how to engage more effectively with public sector buyers. And I have a few recommendations. Firstly, understand the sector. Invest time to know the public bodies that are your potential customers and the regulatory environment, and learn to speak their language. Secondly, public procurement cannot be avoided. As discussed, public bodies are mandated to get value for money for public expenditure and obligated to competitively tender contract opportunities. But there are a variety of routes to market which can increase or decrease your chances of success. Thirdly, do tender for CCS frameworks. No guarantee of work, but a framework procurement is a faster and cheaper way for public bodies to award a contract than conduct of a full public procurement process. Fourthly, make it easy for your customers to buy from you. Public sector buyers are incredibly risk averse, and they're not incentivized in the same way private sector buyers are. They inevitably want gold-plated solutions delivered at the lowest possible price, underpinned by a belts and braces contract should anything go wrong. Finally, bidding is expensive, so don't bid for each opportunity. Where there is a public procurement opportunity, the bid costs can and often are significant because procurements can run for months and require a significant commercial and legal commitment from your organisation. So you need to implement appropriate policies and procedures to qualify and inform your bid decisions. Next slide, and back to Paul.
Thanks, James. So now just a few words on the actual public sector procurement process. So if you are a supplier that's sitting back and just waiting to be invited to participate in a government procurement, then you're probably missing a trick. The more successful suppliers to government are very sophisticated at getting in early and helping the public authorities shape the procurement in a way that works for them. If you're not doing that, there are some ways that you can get visibility of opportunities long before a notice commencing a procurement is issued by a government buyer. For instance, government departments publish pipelines showing when contracts will be coming up for tender. You can also use Contracts Finder to identify not only current opportunities, but what is coming up in the future as well. And don't ignore government frameworks. A huge amount of work is let through frameworks these days, and CCS publishes a list of upcoming framework procurements online. And also look out for prior information notices in areas where your organisation will be well suited to provide goods or services. PINs facilitate early market engagement, so both buyers and suppliers can talk before the tender documentation is released. There has been a steady increase in the use of PINs in public procurement, and it is a good way for you to get involved early and possibly shape the procurement and the buyer's views of what would be the optimum solution. So through early engagement, we've seen suppliers influence the contracting authority's decision-making on a number of areas. For instance, which procurement process to use, whether the authority should procure through frameworks, which the supplier may conveniently be on. And as an example, for instance, if you look at cloud-based technology services, there are a number of overlapping government frameworks. There's G-Cloud, there's DOS, there's BOSS. Now, your organisation may be on some of those, but not others. So you can see why perhaps helping the authority work out which framework is the best one might be to your advantage. Another thing that we've seen suppliers do successfully is influence authorities' decision-making on whether to use a single source or a multi-source contracting model, i.e. whether to go with a prime contractor or a multi-vendor approach. It's certainly up to you, but we'd recommend early engagement. Another area to be mindful of is how you might fall down in the evaluation process, despite your organisation perhaps having the best solution and offering good value for money. Now, because of the transparency requirements, you do get full visibility of the contracting authority's evaluation model, which enables you to understand exactly how the bids will be evaluated. Now, this is incredibly useful, and it allows you to sort of self-assess how your bid will be scored. Now, from our experience, we're very conscious that some suppliers are very risk averse, and they in fact use very heavy markups of government contract terms. Now, at worst, you might be excluded from the competition if the rules of the procurement have asked that you just accept the terms. Otherwise, you might be marked down if the evaluation model deducts points for markups, which again is a common approach that we see. James will be saying a few words later on regarding what are the risks of accepting government terms that are in fact contrary to your organisation's trading terms or exceed your organisation's appetite for risk. Oh, and one other thing which we've seen in practice, you don't want to get a reputation as difficult to do business with. The concern here is that the contracting authority may form a view that your behaviour during the procurement process is indicative of what your behaviour will be like during delivery. Now, different suppliers take different approaches. So do conduct some competitor analysis to assess the approach that your competitors are likely to take on the procurements that you are bidding for. If you are up against suppliers who have a good track record of winning, and again, you can search Contracts Finder to help assess their success rate, you may have to adapt your normal approach for that particular procurement so that you score as high as possible against the evaluation criteria if it's a procurement that you absolutely want to win. So next slide, please, and back to James.
Turning to public sector contracts, a key difference between the public and private sector contracting approach is that public sector buyers buy on their paper, even when purchasing something such as cloud-based services. You might point out that G-Cloud contracts, for example, incorporate supplier terms and conditions, but it's important to remember that those terms and conditions, whilst incorporated into a G-Cloud call-off contract, sit in the lowest order of priority, which means that they are of limited effect. And so, in any event, it's quite a difference to how you might sell such services. When selling to central government, one of the most commonly encountered contracts are the public sector contract, which is designed for use by the Crown Commercial Service in connection with its framework agreements. Mid-tier contract, which is used for or intended to be used for contracts with an aggregate value of less than 20 million, and the model service contract, which is designed for use for contracts with an aggregate value over 20 million. Now, although these contracts are designed for different purposes, they have some common threads. They are lengthy, complex, and pro-customer. Looking at the public sector contract, it comprises 45 documents and runs to a few hundred pages. Model service contract comprises 32 documents, but it runs to 600 or more pages. Whilst you and your organisation, or you and your competitors, may have standard trading guidelines and contracting playbooks that inform what contracting positions you must seek and what concessions you may make. There is no equivalent public sector playbook that informs how public bodies can amend and adapt these documents that I've just referenced, the public sector contract, the model service contract, or the mid-tier contract. In many respects, how a public body responds to a proposed contract amendment will be situation specific, and it's often going to be informed by how many bidders are making the same point and at what stage in the procurement process these points are being made. Because at the beginning of the process, there is perhaps more flexibility to make change, but procurement rules mean that as you get later in the process, particularly if it's a open tender process and there have been bidders removed from the process, that starts to limit the way in which the public body can adapt contract, because it needs to consider the basis upon which these other bidders have been removed from the procurement process. So reviewing and responding to a public contract as part of a bid process is a daunting prospect for many bidders. It's a long and complex document. So your approach to reviewing and responding to the public contract needs to be informed by the invitation to tender. That document will tell you what parts, if any, of the contract are open to negotiation and allow you to assess how your red lines, your pushback, will be evaluated. And as I said a moment ago, where there are points in the procurement process where bidders can be removed, you have to understand that your opportunity to negotiate starts to become more limited as more bidders are removed from the process. Let's look at CCS procurements as an example. So CCS is the biggest public procurement organisation in the UK, and it has set up a vast number of frameworks to enable public bodies to purchase goods and services. When CCS establishes a framework such as G-Cloud, it does so on the basis that provisions are not negotiable. But there are still opportunities for bidders to push back on the framework terms. For example, the clarification process can be used to submit questions to the buyer, to CCS, and as part of that clarification process, bidders can use their questions as a way to effectively negotiate terms with CCS. And at the end of that clarification process, it is open to CCS to publish amendments to those contract documents. So the clarification process is a good opportunity for organisations to push back, even where there is a no bid, a no negotiation rule. And it's a good opportunity in any procurement process because that clarification phase does not form part of the evaluation process. In all likelihood, the draft contract is likely to contain a number of provisions that are inconsistent with your own organisation's trading policies, guidelines. As an organisation, you need to decide, are you playing to win? In our experience, there is often a marginal difference between first place and second place. And this means how you respond to the draft contract, what risks you're prepared to accept, is likely to weigh heavily on your chances, or your organisation's chances of success. So it can be a costly mistake to commence a bid process without firstly understanding how the draft contract aligns with your own organisation's trading guidelines and operational arrangements. And this will inform the extent to which your organisation is able to accept residual risk. Now, going to the point about how these risks can be managed, well, in an ideal world, you would manage them through negotiating changes to the contract. But in the public sector contract context, these risks need to perhaps be categorised and dealt with in a different way. So some of these risks might be operational and be capable of being mitigated through resourcing decisions or changes to policy and procedure. Others are perhaps financial and mitigated through insurance, or others could be delivery risks that could be or should be shared or transferred to your own suppliers, your subcontractors. Next slide, please, and back to Paul.
Thanks, James. So now we're going to turn to look at some of the typical contract red flags that we find suppliers identify. Now, just to note that the red flags that we've selected on this table in front of you on this slide are not an exhaustive list, and they're not actually set out in any particular order of priority. There are many red flags that we've omitted, including those relating to the processing of personal data. But James and I will explain why some of these on this slide are problematic for suppliers. I kick off. We'll just start with IP ownership and open source. Now, there are different variations of IPR provisions in the government contracts that James has mentioned and in some bespoke contracts that get put together. But broadly speaking, any new IPR that's created as a result of the supplier's performance under a contract will typically be owned by the buyer. There'll be provisions in there which oblige you to assign your rights in the IPR created to the government customer. Now, this type of project-specific IPR can include bespoke code, databases, configurations, and technical documentation. Fortunately, it often does exclude the supplier's background IPRs. Now, for most cloud and SaaS solutions, this probably won't be relevant. However, generally speaking, suppliers are often against assigning over IPRs. And so with that in mind, it's important for you as a bidder, as a supplier, to consider instead agreeing appropriate license terms that give the customer the rights that it needs. Now, in relation to open source, in some government contracts, including the G-Cloud terms, all software created for the government customer must be suitable for publication as open source, unless otherwise agreed by the customer. So having to create software that is open source and is not something that suppliers typically want to do. However, as I mentioned, the G-Cloud call-off contract terms do acknowledge that you can agree with the buyer not to have open source, but you would need to expressly agree that with the buyer. Another area which causes concern in relation to IP is the IPR indemnity provisions. Now, these typically specify that the supplier, you, will indemnify the buyer for all losses, and you need to look at what the definition of losses is in the terms, that may be incurred from any claim of infringement or alleged infringement of a third party's IPRs. Often of concern, the supplier's liability under these third-party IPR indemnity provisions is uncapped, so your organization could be carrying unlimited liability there. And again, the indemnity is much wider than, in our experience, suppliers typically provide for in their own trading terms. And as I said, is in respect of any loss that the buyer incurs. It's not linked to or the amount that you would pay under the indemnity is not linked to amounts payable by the government customer under any final award of damages or a settlement approved by yourself. Another concern is that the supplier does not have a termination right in the event that it cannot modify the infringing aspect of the services or procure the right for the buyer to continue to use the services. And finally, in this area, we find that suppliers typically have issues with the conduct and control of the claims wording, in particular with the fact that the indemnity is not subject to the government customer promptly notifying you of the claim, allowing you control and conduct of the claim, and giving you all available information and assistance with to claim. So James, over to you.
Well, turning to the supplier obligations to notify, public contracts impose numerous obligations upon suppliers to notify the customer of certain events. Now, this can be problematic for two main reasons. One is the timescales for notification, and two is the consequences of delay. So on the timescales point, it's common for public contracts to require immediate or prompt reporting notification, or notification within a limited number of working days or even hours. And so this can create organizational challenges for the supplier. The bigger issue can be the consequences of delay, and it's not uncommon for public contracts to state that a failure to notify within the prescribed timescales will be deemed to be a waiver of rights and entitlement to relief and/or compensation under the contract. Moving on to open book and transparency, these are requirements. So certainly open book is a requirement that you're more likely to encounter in a higher value contract, such as the mid-tier contract where contract values are under 20 million, or the model service contract where the contracts are over 20 million. And these situations, the contracts require the supplier and key subcontractors to maintain open book accounts and to allow the public body to audit its books and records. What can be even more problematic for subcontractors is that there is perhaps an expectation, certainly in the model service contract, that the prime contractor will have access to these open book records and an entitlement or expectation that will audit the key subcontractors on the public body's behalf. So open book accounting is something which is perhaps novel for many suppliers, and those suppliers who are unfamiliar with dealing with the UK public sector clients. In addition, another challenge is going to be the transparency provisions. These are provisions that permit public bodies to publish redacted versions of the contract online. There have been recent changes to the transparency guidelines, and there is now an expectation, in addition to publishing simply a copy of the contract, there is an expectation, indeed a requirement, that public bodies publish change notices as well as reports on the supplier's performance against things such as service levels during the term of the contract. Moving on to subcontracting controls, and I'll hand back to Paul.
Thanks, James. Yeah, just a couple of words on the subcontracting provisions in government contracts. So many of the contracts contain terms that provide that the supplier can only subcontract with the prior written approval of the government customer. So that's not really that helpful if you already have your supply chain in place and you do not want to change it to meet a particular government customer's request. So what we suggest is, to avoid problems, certainly down the line, do set out your supply chain, your subcontractors at the contracting stage, and seek to agree wording with the government customer that you can change your subs as long as it doesn't materially affect the provision of the services, and that you will notify the buyer of any new subs you involve in providing the services. Now, that approach is not guaranteed that you will get agreement with the government customer on that, but it's definitely worth a try to avoid having to re-engineer your supply chain for that particular government contract. James, do you want to say something about supply chain interference?
Sure, yeah. So a number of the public sector template contracts include provisions that enable the customer to require the supplier to replace a subcontractor where a customer is able to purchase the relevant goods or services on more favourable terms. This is, a very uncommon right, certainly a right that you wouldn't encounter in private sector contracts. And it is one that is challenged, but the devil is in the detail. The right may only be exercised where the supply is on comparable terms, and certainly in the model service contract, it's subject to the public body compensating the supplier for breakage costs in respect of the early termination of the relevant subcontract. So with those sort of, I guess, qualifications, this means that in practice, it's exceedingly rare or perhaps unlikely that a public body would do this. And certainly, Paul and I were conversing before this webinar, and we can't actually recall a deal or where the public sector buyer client of ours has exercised this right. Moving on to standards and policies, it's not unusual for suppliers to be asked to comply with customer policies, but in context of the public sector, the challenge can lie both in terms of the number of those policies and the fact that they may not be, publicly available or even made available to you during the procurement process. Furthermore, the contract itself may state that these policies are capable of being amended by the customer from time to time, which means it would be outside of the contract variation process and simply updated by notice to you. So this is far from ideal, but actually in our experience, it's not uncommon for public bodies to not have, or frankly not be able to locate these policies that are referenced in these template contracts. Paul.
Thanks, James. A couple of words on 2P, and for those, I'm sure everyone's familiar, but 2P is the Transfer of Undertakings Protection of Employment Regulations, designed to protect employees' employment rights where there is a transfer of an undertaking, which can involve a service contract transfer. So the public sector 2P provisions in the contracts are problematic for a number of reasons, and in fact could be and often are the subject of a completely separate presentation. Concerns relate to controls placed upon the supplier about changing staffing towards the expiry of a contract, and also when you're bidding for a contract, the concerns relate to the staffing information that's provided during the tender process. And typically we hear from suppliers that it's provided very late in the process, and in some cases it's not actually provided at all. Clearly, if you haven't got the information or you get it very late, it's very difficult for you to be making assumptions around staff transfers, and that creates pricing risk for your bid. The other thing which is of concern is the government customer does not oblige itself to indemnify an incoming supplier. It only, for any 2P transfer claims or risks, it only undertakes to endeavour to procure such a 2P indemnity from the incumbent supplier. So if it doesn't actually get one, then you're left with some exposure there. The pensions obligations are also problematic, and we've seen that in a number of very large transactions. And so I guess in summary, in complex transactions where there are staff transferring, typically large numbers, ex-civil servants, there's often a need for you to try and agree reasonable pricing assumptions around staff transfers and pensions, because actually this whole area is very complex, and it's one that we'd always recommend suppliers get some specialist legal advice on, whether it's from their in-house teams if they have it, or otherwise. because if you get it wrong, it can lead to a lot of additional cost for suppliers, which can erode any margin that you are going to be making on some of the deals. I'll just say a couple of words on step-in rights. Again, government builds in step-in rights for itself into its government contracts, and this is a key area of concern for suppliers. It's designed to give government protection in the event of poor or failing performance by the supplier. And typically typically the provisions are drafted so that the step-in is essentially a management step-in, which would allow the government to manage the supplier's resources and assets to ensure that the services continue to be provided to the service levels and the other requirements of the contract. Now, on the face of it, these are very nasty provisions. No supplier likes to agree to them. However, again, in James and my experience, they are very rarely exercised, certainly in IT agreements. We have seen them obviously being used in the area of rail franchising. Actually, back to you, James.
Thanks, Paul. I'll look at the final two issues of liability and customer discretion. In terms of liability, the limits and exclusions of liability are automatic for most suppliers. Customer and the public body's liability is often limited, and those limits are set typically below those of the supplier. The supplier's own liability is often unlimited in respect of its indemnities, and there are typically a number of indemnities given by the supplier. And there are also typically a number of separate liability caps which operate with respect to different supply heads or different heads of loss, which together mean that the risk the supplier is expected to take is a multiple many times higher than what it might be prepared to accept under its own standard terms. Turning to customer discretion, public contracts contain many decision points that are subject to a customer approval rather than objective criteria. And this, typically causes concern for bidders because they might be put in breach as a result of a customer acting unreasonably, or the discretion decision point might mean that there is a delay in them getting paid. So whilst objective criteria would be preferable, there is some comfort in that the Supreme Court has confirmed that where there are discretions, those discretions must not be exercised arbitrarily, capriciously, or unreasonably. Limited comfort, but not comfort nevertheless. Paul, back to you.
Thanks, James. So this is our last slide, and we've just got a few thoughts on here, drawing together some of the themes from our presentation so far on how you can improve your chances of success when, as a supplier, you're bidding for public sector contracts. So I guess the first point we want to just re-emphasize is it's important to consider what your competitors are doing. If your competitors are accepting government contract terms, then you not agreeing to those terms or producing heavy markups are probably going to count against you in the evaluation process. And as I mentioned earlier, you might find that you actually get excluded because the rules of the competition are indicating that you need to accept the terms. It's a mandatory requirement. Or at best, you may find that you're being scored down, which, as James said, because of often we see the fine margins between coming first and second, you may end up losing that particular government contract. It's definitely better to have considered in advance what your organization's appetite is for legal risk. You don't want to be doing that during the actual procurement itself. Some of these procurements have very tight timeframes. Trying to get busy executives within your organization to sign off on positions is just adding a lot of pressure and tension to the whole process. You need to be able to move very quickly and intelligently when these bid opportunities come in. So having done your homework in advance, knowing what you're prepared to agree to, knowing which of the provisions you can accept and you've got some internal approvals for, will stand you in good stead. We also think it's really important to pick the right bid team. Now, for us, this is about building a bridge with the potential government customer. The people you will typically be engaging with in these procurements, they will come from a commercial and operational perspective. And we suggest that your bid team needs to replicate that. So you need to have a team that's led by your commercial and operational people. Having said that, having a multidisciplinary team, including lawyers and finance individuals, is often what produces a good, well-rounded team and can lead to winning tenders. A plea from lawyers, and I know there's a number of lawyers on the call, I'm sure you'll all agree with me that the sooner our clients get us involved in these opportunities, the better. The sooner we know about the opportunity, then that's when we can start to provide most value. Because a lot of what we've been talking about today is stuff that's front-loaded and things which you can make a difference before you even give your lawyer the contract to review. The other thing which we'd stress is do use the evaluation model to evaluate what your own tender response would score. So unlike in the private sector, where you often don't know what evaluation criteria is being used to assess your bid, due to the transparency obligations that we've mentioned, you do get visibility of the evaluation model. And this allows you to self-assess your bid responses and to estimate how well you think you will score against that evaluation model. And then finally, recognizing that you don't win every bid that comes along, it is important to conduct some reviews, some autopsies, both on the bids where you have been successful, to understand why you've been successful and to hopefully use that for future bids. But more importantly, perhaps to understand where you've been unsuccessful and there's areas for development. So again, you can build that into your future bids for government contracts. So that concludes the comments that James and I wanted to make to you today. But we have got some time for questions and answers. So I'm very happy to open it up to any questions. And feel free to make any observations as well about your experience contracting with the public sector.
So, Paul, I can see we've got one question that has come in, which reads, you mentioned that alliances often work in the public sector. Can you tell me who are usually members of such alliance? Who does it consist of? If we have a product built on open source code, who should we start looking for an alliance with? Now, perhaps if I just say a few words in response and then you can pick up on that thread. So I think in my experience, alliances form in response to specific contract opportunities where a prime contractor or a set of organizations identify that particular products, when put together, will give them a competitive advantage. And in those circumstances, whether it's bidding as a consortium or you've got a prime contractor, what you really need to bid successfully in that sort of situation is, a robust teaming agreement where the parties understand who is taking the lead on the bid, what provisions would be flowed down to the consortium members or the proposed subcontractors, and how the to the extent that there would be negotiations, how those negotiations would be conducted, who would be present. But Paul, do you have any further thoughts on this question?
No, I think you've covered that, James. So I think that I can see a second question that's come in relation to PB and pricing assumptions. Maybe we could just have a look at that. I'm just actually, James, I'm just struggling with my screen to see the full question. Do you mind just reading it out?
Yes, I too. Let me see this question.
Or Jess, if you're on the line, are you able just to read that out for James and I?
Yeah, so you mentioned including a pricing assumption in relation to TUPE. Please could you explain how that would work? What would be what would be the impact of including an assumption, and where could you include it in a bid?
Yeah, so typically pricing assumptions need to be kind of agreed well with the government buyer. It's in my experience, you turn to assumptions when the information about the staff that are likely in scope for transfer is not as detailed or robust as you would like it to be. It could well be that the assumptions come actually from the government customer because they need to give the same information to all bidders to allow them to be on a level playing field. So although the information is not fully accurate, then some information is provided, and then your bid is permitted to be made on the basis of that assumption. But sometimes also it might be worth engaging with the government customer if you feel that the information either hasn't been provided or doesn't allow you to properly scope what the costs would be for taking on existing employees that might well transfer over. And where you might include it, well, it really goes down to the bottom line in terms of the pricing of your commercial proposal. So you typically, I think you could have some wording which makes it clear in your commercial proposal that it's been based on the following assumptions, and then if you are selected to go through to preferred bidder stage and or enter into the contract terms, then I think you'd want to include those assumptions as part of the contract terms in relation to the price that's being paid for the service or the supply. Okay, are there any other questions? Jess, can you see any other questions?
There hasn't been any more come in, no.
Okay, well, if there are no other questions, and feel free afterwards, by the way, I think you've got the contact details for James and I. If you do have some questions afterwards, by all means, email us and we'll do our best to give you a steer on those. But if there are no other questions, thank you very much for all of those who have joined today. I hope you found some of the comments have been helpful, and good luck with your public sector contracts and hopefully winning more business in the public sector. Thank you for joining.
Thank you.